ओम नमो भगवते वासुदेवाय। The following are the key differences between the Memorandum of Association versus Articles of Association. Objectives. Memorandum of Association defines and delimits the objectives of the company, whereas the Articles of Association lays down the rules and the regulations for the internal management of the company. Articles determine how the objectives of the company are to be achieved. Relationship. Memorandum defines the relationship of the company with the outside world, and articles define the relationship between the company and its members. Alteration. Memorandum of Association can be altered only under certain circumstances and in the manner provided for in the Act. In most cases, permission of the religion director or the tribunal is required. The articles can be altered simply by passing a special resolution. Ultra-virus acts done by the company beyond the scope of the memorandum are ultra-virus and void. These cannot be ratified even by the unanimous consent of all the shareholders. The Act's ultra-vires. The articles can be ratified by a special resolution of the shareholders, provided they are not beyond the provisions of the memorandum. Doctrine of indoor management. Doctrine of constructive notice. Section 399 of the Companies Act 2013 provides that any person can inspect by electronic means any document kept by the registrar or make a record of the same, or get a copy or extracts of all documents, including certificate of incorporation of any company, on payment of prescribed fees. The memorandum and articles of association of a company, when registered with registrar of companies, becomes become public documents are and they are available for inspection to any person on the payment of a nominal fees. In other words, Section 399 confers the right of inspection. The memorandum and articles of association of a company, when registered with registrar of companies, becomes public documents and they are available for inspection to any person on the payment of a nominal fee. In other words, Section 399 confers the right of inspection to all. It is therefore the duty of every person dealing with a company to inspect its documents and make sure that his contract is in conformity conformity with their provisions. But whether a person reads them or not, it will be presumed that he knows the of contents of the documents. This kind of presumed implied notice is called constructive notice. By constructive notice is meant whether a person reads the documents or not, he is presumed to have knowledge of the contents of the documents. He is not only presumed to have read the documents but also understood them in their true perspective, and every person dealing with the company not only has the constructive notice of the memorandum and articles of the association, but also of all the other related documents such as special resolutions etc., which are required to be registered with the registrar. Thus, if a person enters into a contract which is beyond the powers of the company as defined in the memorandum or outside the authority of directors as per memorandum or articles, he cannot acquire any rights under the contract against the company. Doctrine of indoor management. The doctrine of indoor management is the exception to the doctrine of constructive notice. The aforesaid doctrine of constructive notice does in no sense mean that outsiders are deemed to have notice of the internal affairs of the company. For instance, if an act is authorized by the articles or memorandum, an outsider is entitled to assume that all the detailed formalities for doing that act have been observed. This can be this can be explained with the help of landmark case, the Royal British Bank versus Tronquand. This is the doctrine of indoor management, popularly known as Tronquand rule. Tronquand rule. Exceptions to the doctrine of indoor management. Thus, you will notice that the aforementioned rule of indoor management is important to persons dealing with a company, through its directors or other persons. They are entitled to assume that the acts of the directors or other officers of the company are validly performed. They, if they are within the scope of their apparent authority, so long as an act is valid under the articles. If done in a particular manner, an outsider dealing with the company is entitled to assume that it has been done in the manner of required. An outsider dealing with the company is entitled to assume that it has been done in the manner required. The above mentioned doctrine of indoor management or Pronkoand rule has limitations of its own. That is to say, it is inapplicable to the following cases, namely actual or constructive knowledge of irregularity. The rule does not protect any person when the person dealing with the company has notice, whether actual or constructive, of the irregularity. Suspicion of irregularity. The doctrine in no way rewards those who behave negligently, where the person dealing with the company is put upon an inquiry. For example, where the transaction is unused, unusual or not in the ordinary course of business. It is the duty of the outsider to make the necessary inquiry. Forgery. The doctrine of indoor management applies to applies only to irregularities which might otherwise affect a transaction, but it cannot apply to forgery, which must be regarded as nullity. The plaintiff contended that whether the signature were genius or forget was um, forget was a part of the internal management, and therefore the company should be stopped stopped from denying the geniusness of the document. But it was held that the rule has never been extended to cover such a complete forgery. Des- Descriptive questions. What is meant by a guarantee company? State the similarities and dissimilarities between a guarantee company and a company having a share company limited by guarantee. Section 221 of the Companies Act 2013 defines it as the company having the liability of its members limited by the memorandum to such amount as the members may respectively undertake by the memorandum to con- to contribute to the assets of the company in the event of its being bound up. Thus the liability of the member of a guarantee company is limited up to a stipulated sum mentioned in the memorandum. Members cannot be called upon to contribute beyond that stipulated sum. Similarities and dissimilarities between the guarantee company and the company having share capital. The common features between a guarantee company and share company are legal personality and limited liability. In the latter case, the member's liability is limited by the amount remaining unpaid on the share, which each member holds. Both of them have to state in their memorandum that the member's liability is limited. However, the point of distinction between these two types of companies is that in the former case the members may be called upon to discharge their liability only after commencement of the binding up and only subject to certain conditions, but in the latter case they may be called upon to do so at any time, either during the company's lifetime or during its binding up. Can a non-profit organization be registered as a company under the Companies Act 2013? If so, what procedure does it have to adopt? Yes, a non-profit organization be registered as a company under the Companies Act 2013 by following the provisions of Section 8 of the Companies Act 2013. Section 8 of the Companies Act 2013 deals with the formation of companies which are formed to promote the charitable objects of commerce, art, science, sport, education, research, social welfare, religion, charity, protection of environment, etc. Such a company intends to apply its profit in promoting its object and prohibiting the payment of any dividend to its members. The the central government has the power to issue license for registering a Section 8 company. Section 8 allows the central government to register such person or association of persons as a company with limited liability without the addition of words limited or private limited to its name by issuing license on such conditions as it deems fit. The registrar shall on application registered register such a person or association of persons has a company under this section. On on registration, the company shall enjoy some privileges and obligations as of a limited company. Briefly explain the doctrine of ultra vires under the Companies Act 2013. What are the consequences of ultra vires acts of the company? Doctrine of ultra vires. The meaning of the term ultra vires is simply beyond their powers. The legal phrase ultra vires is applicable only to acts done in excess of the legal powers of the doers. These presupposes that the powers are in their nature limited to an ordinary citizen. The law permits whatever does the law not expressly forbid. It is a fundamental rule of company law that the objects of a company has stated in its memorandum can be departed from only to the extent permitted by the Act. Thus far and no further has Wari Railway Company Limited versus Riche. In consequences, any act done or a contract made by the company which travels beyond the powers not only of the directors but also of the company is wholly void and inoperative in law and is there and is therefore not binding on the company. On this account, a company can be registered. On this account, a company can be restrained from employing its fund for purposes other than those sanctioned by the memorandum. Likewise, it can be restrained from carrying on a trade different from the one it is authorized to carry on. The impact of doctrine of ultra vires is that a company can neither be sued on an ultra vires transaction nor can it sue on it. Since the memorandum is a public document, it is open to public inspection. Therefore, when one deals with a company, one is deemed to know about the powers of the company. If in spite of this you enter into a transaction which is ultra-virus the company. You cannot enforce it against the company. For example, if you have supplied goods or performed service on such a contract or lent money, you cannot obtain payment or recover the money lent. But if the money advanced to the company has not been expended, the lender may stop the company from parting with it by means of an injunction. This is because the company does not become the owner of the money, which is ultra-virus. The company has the lender remains the owner. He can take back the property in spice if the ultra-virus loan ultra-virus loan has been utilized in meeting lawful debt of the company. Then the lender steps into the shoes of the debtor, paid off, and consequently he would be entitled to recover his loan to that extent from the company. An act which is ultra-virus the company being void cannot be ratified by the shareholders of the company. Sometimes act which is ultra-virus can be regularized by ratifying it subsequently. For instance, if the act is ultra-virus, the power of the directors, the shareholders can ratify it. If it is ultra-virus, the articles of the company can alter the articles. If the act is within the power of the company but is done irregularity, shareholder can validate it. Shareholder can validate it. Explain clearly. The doctrine of indoor management has applicable in cases of companies registered under the Companies Act 2013. Explain the circumstances of in which an outsider dealing with the company cannot claim any relief on the ground of indoor management. Doctrine of indoor management. The Companies Act 2013. According to the doctrine of indoor management, the outsiders dealing with the company turf are supposed to have satisfied themselves regarding the competence of the company to enter into the proposed contracts, are also entitled to assume that as far as the compliance internal compliance to procedures and regulations by the company is concerned, everything has been done properly. They are bound to examine the registered documents of the company and ensure that the proposed dealing is not inconsistent therewith, but they are not bound to do more. They are fully entitled to presume regularity and compliance by the company with the internal procedures are required by the memorandum and the articles. These doctrine is a limitation of the doctrine of constructive notice and popularly known as the rule laid down in the celebrated case of Royal British Bank versus Tronquand. Thus, the doctrine of indoor management aims to protect outsiders against the company. The above mentioned doctrine of indoor management or Tronquand rule has limitations of its own. That is to say, it is inapplicable to the following cases, namely actual or constructive notice or irregularity. The rule does not protect any person when the person dealing with the company has noticed, whether actual or constructive, of the irregularity. In Howard versus Patent Inventory Manufacturing Co. Where the directors could not defend the issue of debentures to themselves because they should have known that the extent to which they were lending money to the company required the assent of the general meeting, which they had not obtained. Likewise, in Morris versus Cancine, a director could not defend an allotment of shares to him as he participated in the meeting which made the allotment. His appointment as a director also fell through because none of the directors appointed him was validly in office. Suspicion of irregularity. The doctrine in no way rewards those who behave negligently where the person dealing with the company is put upon the inquiry. For example, where the transaction is unusual or not in ordinary course of business, it is the duty of the outsider to make the necessary inquiry. The protection of the Trunk-One rule is also not available where the circumstances surrounding the contract are suspicious and therefore invite inquiry. Suspicion should arise, for example, from the fact that an officer is purporting to act in matter which is apparently outside the scope of his authority, where, for example, as in the case of Anand Bihari Lal versus Dinso and Co. The plaintiff expected a transfer of a company's property from its accountant. The transfer was held void. The transfer was held void. The plaintiff could not have supposed, in absence of a power of attorney, that the accountant had authority to effect transfer of the company's property. Similarly, in the case of Hogan and Co. versus Northard Lowe and Wills Limited, where the person holding directorship in two companies agreed to apply the money of one company in payment of the debt to other. The court said to it was something so unusual that the plaintiffs were put upon inquiry to ascertain where the persons making the contract had any authority in fact to make it. Any other rule would place limited companies without any sufficient reasons for so doing at the mercy of any servant or agent who should purporting of any servant or agent who should purport to contract on their behalf. Forgery. The doctrine of indoor management applies only to irregularities which might otherwise affect a transaction, but it cannot apply to forgery, which must be regarded as nullity. Forgery may, in circumstances, exclude the truculent rule. The only clear illustration is found in the Reuben versus Great Fingal consolidated. In this case, the plaintiff was the transferee of a share certificate issued under the seal of the defendant's company. The company's secretaries who had affixed the seal of the company and forged the signature of the two directors issued the certificate. The plaintiff contended that whether the signature were genius or forged was a part of the internal management, and therefore the company should be stopped from denying geniusness of the document. But it was held that the rule has never been extended to cover such a complete forgery.